In a contested will litigation, can an estranged daughter who receives nothing under the will oppose summary judgment? To find out, you have to read Matter of Lowrey, but it's 2 pages. Don't have time for that? I've got you covered. This is TLDR, Too Long Didn't Read, where normally I cover New York Court of Appeals cases, and I try to do that in 5 minutes or less. But this is part of a special limited series I'm doing on cases relevant to the elder law and estate planning community. This is the recent case of Matter of Lowrey by the Appellate Division 3rd Department on March 7th, 2024. The citation for this case is 2024 New York Slip Opinion 01222. And the issue in this case is whether a party can defeat summary judgment trying to probate a will on the basis that the decedent failed to provide for his daughter, had a history of alcohol abuse, and only had a general knowledge of his assets. The background that's helpful to understand this case is first SCAPA, the Surrogates Court Procedure Act 1404, talks about what you need to probate a will. And basically, to probate a will, you need to have at least 2 of the witnesses to the will's production produced before the court and examined if they are within the state and competent and able to testify. That's a basic presentation of the evidence in favor, in support of the will that's being offered for probate. The other thing that's helpful to know is that EPTL, Estates Powers Trust Law 3-1.1, talks about who can make a will and what are the prerequisites to making a will. And it basically says that every person 18 or over of sound mind and memory may, by will, dispose of their real and personal property. Okay? So it's 18 or over and of sound mind and memory, and that's been called testamentary capacity. What are the facts of this case? The facts are that the subject in this case is John Lowrey. And John Lowrey had a brother and a daughter. And the daughter was estranged from him for 25 years. He and his daughter had basically no relationship for 25 years. And in 2017, John Lowrey executed a will, naming his brother to be the executor and sole distributee if he survived John Lowrey. So if John died, everything would go to the brother. He gave nothing to his daughter. Almost 3 years later, Lowrey died, and his brother became the petitioner offering the will for probate. At that point, the daughter came out of the woodwork and said, "No, I object." She filed objections to the will's validity. She invoked the discovery provisions of SCAPA 1404, which allowed her to examine the witnesses to the will's execution. The brother moved for summary judgment to admit the will and dismiss the objections. The petitioner presented the testimony of the 2 witnesses to the will's execution, his own affidavit and testimony. The daughter, to try to show that this should not be granted, the summary judgment should not be granted, she tried to raise the issue of testamentary capacity, claiming her dad lacked testamentary capacity by showing, first, medical records showing a history of alcohol abuse that the decedent had during his life. Second, she argued that he lacked any provision for his daughter, which is a problem. And third, she said that he had an expression of only general understanding of his assets, not a precise understanding of all of his assets. And lastly, she made some conclusory allegations of undue influence and fraud by the brother, but didn't specify dates, times, places, all that stuff. The surrogates court then granted the motion for summary judgment, and the daughter appealed. Granted the motion for summary judgment by the will's proponent, by the brother. It goes to the Appellate Division 3rd Department, and here's the holding. The holding is, there's 2 issues. First, they say, at a separate matter, they say the appeal is untimely. You only have 30 days to appeal the issuance of the order, and this was 1 day late. This was 31 days. So that's the first part. But apart from that, they say, even though this appeal is untimely and that's jurisdictionally defective, we're going to address the merits of this case. And as to the merits, they say, summary judgment in a contested probate proceeding is valid. A petitioner can seek summary judgment saying, "I win," if the petitioner establishes a prima facie case, shows that, all the requirements of a will. And secondly, if the objectant fails to raise any factual issues regarding testamentary capacity, execution of the will, undue influence, or fraud. And here, that was the case. The brother put forward the evidence necessary, put the 2 witnesses forward required by SCAPA, and the daughter failed to raise the questions of fact sufficient to challenge the will. So all those things the daughter raised as issues were insufficient to overcome summary judgment for the brother petitioner, executor of the will. The surrogate was correct. the will shall be probated. And that's the case of Matter of Lowrey. Have a good day. If you like what you just saw and want to see more just like it, please hit like or subscribe to let me know.